Good morning, good afternoon, everybody. My name is Michael, and I'm going to be your instructor for this course over the next 4 days on airline contract law, managing contracts in good and in difficult times. Let me first share. Let me ask you to introduce yourself a little bit. I would like to know more about you, your name, your position, your exposure to aviation contract law, and in particular what you're interested in taking away from this course. That enables me to address your concerns or those areas which you're particularly interested in a bit stronger as we go through the course. Let's just start with Alexandra, please.
Yes, hello. Thank you. My name is Alexandra, and I have some experience working with the industry. What I'm more interested in right now is to understand better the relationships between code sharing and interlining. That's the area that I would like to expand more on. Thank you.
Thank you very much. Yes, and that's something we're going to look into in very much detail as we go a bit further through the course. More to the end of the course, we look into not only the contractual mechanics, we will in detail examine those agreements, but also we look into the concept that is behind these very often used concepts in the industry. Yeah, thank you very much. And I would like to know from you where you are from, where you're currently based, and also where you're from. This gives us an opportunity to use the annotation tool. So let's just use the little arrow. And I start with myself. My name is Michael, and I'm from originally to Germany. And I am currently based down here in Southeast Asia in Singapore. So where are you from and where are you currently based? Please use the, yes, Alexandra. Very good. Anna, great. Dylan, Philip, Lester. Okay. Thank you very much. So we have representatives from all over the world, and that's just what aviation is about. Thank you very much. Let me introduce you very briefly what we're going to do over the next four days. We have basically 4 core modules split over 4 days. We will first of all now, right after this introduction, look into legal systems, the legal systems that we are operating in this world, and most of all how they differ, to resolve some very critical myths about the differences between these legal systems. We will then move on and look into general contract law. We look into the life cycle of an agreement. How is it going to be formed? What elements are required? How does an agreement come to an end before we then move on to the more specific contract law? We will look into very specific clauses. We look into indemnity, but also liability limitations, termination provisions, force majeure, the concept of frustration, talent high water clauses, just to name a few, and most of all, the enforcement of an agreement. No agreement has any value if you choose the wrong non-jurisdiction clause and you end up not being able to enforce it on the other party if push comes to shove. All right? And at the end of this day, further down the course, we will then look into very specific airline agreements. We will look into airline corporations, dry wet lease, damp leases, but also interline and code sharing. We look into charter. We examine block space agreements and their indemnities, for example. We look into services and procurement agreements. Typical examples would be ground handling. You just mentioned those ground handling agreements, but also jet fuel purchase agreement and catering agreement. Both agreement types that can actually cause a lot of harm to an airline. Okay, and then we will close our session with having a closer look at conditions of carriage and amendment and donation agreements as well. Okay, so that's what you can expect for the next 4 days. Let me just introduce the airline and its suppliers. The airline has a multitude of agreements in place that are constantly renegotiated, renewed, or set up with, for example, ground service providers, jet fuel suppliers, caterers, and also lessors and charterers, airport operators, and many, many more. All of these are connected through contractual relationships, and this is what we're going to look into very closely in this course. Contract law in particular, let's start with the 2 legal systems we have in this world. Which legal systems do we have and how do they differ? It's a bit of a myth, and there's a lot of uncertainty among a lot of parties when we do cross-border transactions and we encounter legal systems of other parties in other jurisdictions. So let's have a close look at what are the main dominating legal systems we are operating in throughout the globe. There are two main legal systems as sources of law. One is on the right, the civil law legal system. The other one is on the left, the common law legal system. Yeah, the common law legal system is a judicial precedent and judge-made law, also called case law. It basically derives from court decisions, which then arise as precedents. Courts would then be bound to each other against these precedents. Civil law, on the other hand, here on the right, here's the application tool, second. Here, civil law, it is created by Parliament, just note the difference, as opposed to judicial law, also called precedent law. There are no precedents deriving from one decision over another. So courts are not bound by the decisions of other courts. They will refer to them to get an opinion and a view and look into the reasoning, but they're not necessarily bound by that. So common law legal system, a bit in more detail. It's very widely used, in particular when we're talking about contract law. For example, in disputes about the law, a common law court would turn to part decisions, those precedents, that means court decisions that have been decided in the past, and then it would synthesize the principles, from those court decisions, and it would apply them at the new facts at hand. So that's when it refers to the past decision and it takes the rationale out of these past decisions and applies it to current law. Now that's what we're saying with when courts are bound by these court decisions, by previous court decisions. If a similar dispute has been resolved in the past, the court is usually bound to follow the reasoning used in these prior decisions, and that's what we call the stare decisis here in brackets. If the court, however, finds that the current dispute is fundamentally different from previous court cases the court has looked into, and legislative statutes, that's codified law, are either silent or ambiguous on the question, the court then forms an opinion that gives reason for a new decision. Okay? Such decisions, however, together with past precedents, then try and bind future courts and litigants. Common law, remember, is made by judges, by courts, as opposed to law made by Parliament. On the other hand, civil law legal system, whereas one of the main differences, the law is made by the Parliament. It is not created by the courts. The court's function is to interpret written law. Civil law lawyers, for example, would consult case law, but mainly to get a good estimate and a good view about a court's position, and it would then apply them and gives them a good idea of how the court case could turn out. Statutes in civil law legal systems are usually very detailed and are not precedents. Previous court cases are not binding on courts. Typical example of civil law legal systems would be countries in continental Europe, Germany, France, Italy. Typical example for common law legal systems would be the United Kingdom, Singapore, Hong Kong, the United States, part of South Africa, Australia, of course. In reality, however, there are a number of hybrid systems. If you look at this link, for example, it gives you a very good overview how these legal systems are distributed across the globe and where they differ and what other influence they have. So in reality, there are a number of hybrid systems as well. So why does this all matter? We have two legal systems, so where is actually the difference and where are the similarities? Again, cross-border transaction and cross-border contracts very often bring along a lot of uncertainty among parties. There's uncertainty about the other party's legal system, and very often there is even a dispute on which law to apply. To put some ease to mind here, the difference in these two legal systems is not so much the content. Actually, the concepts of law are very much aligned. The only real big difference is the source of law. source of law in common law legal systems, courts would create the law. In civil law legal systems, it would be created by Parliament, it would be written and very well and detailed documented law. But the concepts are very much the same. So whether we draft an agreement under common law or civil law, the content would most of the time be the same or very similar, a few exceptions, of course. There is not much to worry about major differences per se. So let's have a look at the life cycle of a contract. How does it come into existence and how does it actually end? Yeah, we have a number of requirements that need to be met for an agreement to come into existence. It usually starts with an offer and acceptance. That means two declarations of will that are meeting the mind. That means both are on the same page, both parties intend to bring about legal binding effects over a certain content at a certain point of time. You need an offer and acceptance. You need consideration under common law. Under civil law, you do not need consideration. What is consideration? Consideration is anything that needs to be exchanged of value. For example, you can even buy an aircraft for just $1. In a civil law country, however, you do not need something of value in return to form a binding contract. For example, if you are giving away freely your car without being paid for it, and you agree on that with another party, that would be a binding contract in a civil law country. That's one of the exceptions. All right. Next requirement is that the formation and the performance of the contract is meeting the law. That means it must not be illegal and it must not be against public policy. To give you an example, it would be illegal to possess or to sell drugs. In most countries, that would be illegal. So forming an agreement for the sales of drugs, for example, would simply be illegal because it is lacking this fourth element here. Yeah, the formation and the performance. So the handing over of drugs would simply be illegal. What else do you need? You need legal capacity. That means you need to be of legal age or you need to be properly authorized if you are entering into an agreement. How do you end an agreement? An agreement also gets ended by a declaration of will by way of a notice to effect termination. That usually happens based on a contract under the concept of a contractual termination. There is another concept, and that's the concept of law, and that's the doctrine of frustration, which also brings obligations to an end. We will look into this in a moment. Yeah. Let's first have a brief look at the typical term and termination clause and its structure. You would have a first layer that would mention the starting day and how long the agreement is supposed to go. Very often it could run for an unlimited time, so it would be open-ended. Sometimes you would find an agreement to be just for an initial or for a limited time period. The second layer would give parties ordinary termination right. That means a party can terminate an agreement at convenience without reason, but they have to observe a certain notice period. Yeah, once they've given notice, the notice period starts running, and once the notice period has come to its end, the agreement has come to its end. You would have a third layer, that's an immediate termination right, and that would allow parties to terminate with immediate effect, but only in very, very narrow cases. For example, if a company becomes insolvent or has any kind of payment issues or becomes administered by for example, bankruptcy court. Yeah, that would allow the other party to immediately terminate this agreement. And last but not least, we have the fourth layer, and that would be usually the force majeure process, in which parties can agree what force majeure is, and the force majeure process would then suspend obligations for a certain amount of time, and if that time goes on too long, the agreement would then also stipulate that the parties may terminate after a certain way. But let's have a very quick look at what the concept of frustration actually means. Just imagine discharging of obligation becomes impossible. What do you do now? And there are a number of things you can do. Yeah, the doctrine of frustration is a legal concept. It has been formed by courts in common law jurisdiction, and it is actually stipulated in civil law jurisdiction. So again, here you have a very good example of how the same concept is available in both legal systems, just their placement and their origin is a little different. So what's a frustrated contract? A frustrated contract is a contract that's subsequent, so after its formation, and without any doing, without any fault of either party, becomes incapable of being performed due to unforeseen events. If that is the case, what will be the consequences? The consequences of a frustrated contract would be the automatic termination of that obligation at the point of frustration. So the agreement is not void ab initio from its beginning, but only from the moment a frustrating event actually happens and stops one party from discharging its obligation. Any obligation that was due before that event do, of course, have to be discharged. Now, this is not necessarily something that is desirable by some of the parties. Very often parties, in particular in long-term agreements, they would simply want to suspend their obligations rather than having an agreement basically come to an end with immediate effect. So this is where a force majeure provision would help them a bit better. But we will look into this mechanics a little bit later. Let me now just move on to a number of scenarios. Okay, so we have scenario 1, for example. Just imagine COVID-19 hits the world and bookings, for example, of an airline decline. Borders are still open and no restrictions to operations are imposed. An airline, however, decides to cancel flights as it seems unprofitable. Would you consider this to be an event of frustration? If so, give me a green tag. If you don't think so, then give me a red X in the feedback tool down there, please. Okay, we have 1, 2 yeses, we have 3 no's. Yeah, majority says no. All right, I give you, before we solve this miracle, bear with me, we do the same again with a separate scenario. This time the situation has changed slightly. Again, COVID-19 has entered the world, bookings decline, now borders are closed, and fleets are grounded based on government restrictions. Do we now have an event of frustration? Please vote again. Yes, I see the vote is changing. So let's have a look at the outcome of this. All right. So that's the result. Absolutely. Scenario number 1 was no frustration. In fact, the airline decided not to operate the flight. They could have still operated the flight. And by not doing so, they were breaching their contract with passengers. Yeah. So it was still possible, and they would simply not want to operate for commercial reasons. That would not relieve them from their obligation. So no frustration here. Scenario 2, yes, absolutely. Now we have an event of frustration. Airlines can no longer operate because it simply has become illegal or impossible. That's the concept of frustration. And in this moment, they are relieved from their obligation to operate.